Thank you, Judge Noel, to join us as well. But let's get started. So welcome, everyone. I'm Lisa Chapman with Michigan Coalition Against Homelessness, and today we are so fortunate to have a great panel talking about court and legal aid best practices during the pandemic, challenges, innovations, and lessons learned. So you can go to the next slide, please. Here's the agenda for our panel discussion today, and we will be starting with introductions and kind of setting the stage, and then getting some thoughts and discussion on pandemic challenges, best practices, and innovations that have occurred. And, you know, now that we're almost 2 years in, what lessons have we learned in doing this work? So we will be fairly informal today. So if you have thoughts or questions for the panelists, or just general observations from, you know, your community work, please put them in the chat and we will get to them, or you can put them in the Q&A, but mostly we'll be monitoring the chat along the way. So I want to thank you for being with us today. Let me introduce our panelists now, and I'm so excited to have them with us. We have the Honorable Sheila Johnson with 46th District Court. The Honorable Judge Johnson is Chief Judge with Southfield 46th District Court. So excited we did work together in the EDP and SARA program, and Judge Johnson received her undergraduate degree from Dartmouth College and her JD degree from University of Michigan Law School. Judge Johnson served as a judge with the district court since 2002 and was the first African-American judge to serve in the 46th and the first African-American female judge to serve as district judge in Oakland County. She has served on the board of directors with the Judicial Council of the National Bar Association and is the immediate past president of the Michigan District Judges Association. She has received so many awards and honors, there are too numerous to mention here, but I'd like to welcome her to our panel. And also thank you, Judge Johnson. And I'd also like to welcome the Honorable Bradley S. Noel. He's with the 58th District Court, and he's the Chief Judge there as well, which is located in Ottawa, Michigan, the Holland area. Judge Noel has served as a judge for the court since January of 2003. Judge Noel received his undergraduate degree from University of Michigan and his JD degree from Michigan State University College of Law. I'd also like to welcome Shannon Lucas, who is the Director of Advocacy for the Michigan Advocacy Program, which provides free civil legal aid to low-income individuals in 13 counties in South and Central Michigan. Shannon is a graduate of University of Michigan and the University of Toledo College of Law. Prior to her current role as a Director of Advocacy, Shannon served as staff attorney and a managing attorney for MAP. And last but not least, Emily Calabrese, who's the Director of Advocacy for Lakeshore Legal Aid. Emily, if you are you there? Let's see, I'm gonna scroll over and there she is. Hi. So Emily is now the Director of Advocacy at Lakeshore Legal Aid. She was formerly a supervising attorney, probably does some of that still. She practices in the areas of family law, landlord-tenant law, and domestic violence issues. She's a member of the State Bar of Michigan's Family Section in the Macomb County Bar Association. Ms. Calabrese is an MSU alumni. Go Green. All right. Thank you so much, our panelists. So let me now just do a little bit of setting the stage, and Eleanor, if you can advance our slide. Just wanted to really give some quick background on the coalition's involvement with this effort. And we're fortunate enough to get an ERASE grant, which stands for End Rental Arrears to Stop Evictions, from our partners at the National Low Income Housing Coalition. So this is a year-long grant, and we're doing this as part of a national cohort of 38 partner organizations from around the country. We provide education, information, awareness raising, and working with our partners around the state who are administering the SARA program. We are also doing this work in collaboration with MISTA, and we really, our goal is to have the SARA program run as smoothly as possible and committed to adapting best practices. So with that, we'll go to the next slide, and just a little background on how we got started with this whole effort. The first round of funding was the EDP funding that came into being in July of 2020, and Michigan got 50 million, and then there was 10 million for legal aid funding around the state. And then the SARA program came in with funding from Treasury, federal funding with 2 tranches. 660 million in the first round that was appropriated a year ago now. And ERAP 2 was appropriated from Treasury in March. And also, I do want to say that 140 million of this 523 just got appropriated in a supplemental budget bill that was passed yesterday. So at least some of the ERAP 2 funding has been appropriated, which is very good news. And then, just talking about some of the state court orders that came down, and I know our legal partners and our judicial partners will talk a little bit about this to, protect health in the pandemic and how courts would operate, prioritizing scheduling of cases. It involved, right to counsel and rental assistance funding. So we will definitely talk more about that along with our discussion today. So let's go to the next slide. And first, and I'm just going to be very informal. So panelists, as you want to answer the questions, let's have our panelists weigh in now on what were the challenges just in starting these programs.
Well, I guess I can start from the
Please, Judge Johnson, thank you.
Perspective, and I know that some of our legal aid representatives here probably have understood the challenges from our perspective as well. When we first started with the COVID process, there was no guidance at all, basically. And so I actually decided that this court wasn't going to evict anybody under the circumstances because there weren't any administrative orders out. I was struggling to find some authority for that, and there really was no authority to tell me that I couldn't process these cases. So I called my I called my state representative. I said, are you all going to be passing any laws about this because COVID is here? I called my city council and asked, are you going to do anything on the local level with respect to anything about housing evictions? And, if they were, they didn't. And it was up to me to find a solution. So that was the beginning of my process, was to find some kind of way to stop these evictions because we were steadily getting hundreds of these cases. If you don't know, the 46th District Court, we have about 100 cases for every landlord-tenant docket, and we have at least 9 dockets a month. And so that's literally up to 900 to 1,000 cases that we're processing regularly. And attorneys are, were used to a quick processing and turnaround, and then suddenly everything stopped. And so I had to put some orders in place at that time, which I kind of did. And basically I kind of stayed this processing up until we got our first administrative order. And I think I pulled a copy just to remind myself what I did. I had a standing order that I entered, and it basically said that we were going to based upon, it started with the Centers for Disease Control order, which wasn't a law at that point in time. Subsequently, it was adopted in the law, so it had teeth in it. But because it was out there, we kind of followed that as a little bit of a guidance, and it had halted residential evictions effective like from September 2020 until December 31st of 2020. So we tried to adapt to that, and we decided that if there was any action to remove people from their apartments due to non-payment of rent, that we really weren't going to accept those cases if a declaration had been filed. We were just going to not accept them. Then at a point we did accept them and we did nothing with them. And then that order kept getting amended. Then it was adapted into law. And as you know, I think it was in force up until this year, like June or something of 2021.
Right.
So we really had to struggle to find a way to stay these cases and keep track of them. Literally, there were hundreds of cases in various different points of progress. Some were submitted, they weren't filed. Some were submitted and had been filed, but they were kind of stayed. So we were kind of all over the place as to what we were doing and how to keep track of things. Then we found out that once we got to the administrative orders and we were in an EDP processing situation, there was really no real guidance on the first EDP program. It's like we knew it was out there. We kind of told people that it was there. We had problems really with people understanding what that was. We were trying to get lawyers in to represent them. So we got Lakeshore Legal Aid in on this. We couldn't have our hundreds of people come in. So we became innovative, and I guess I'll hold off till that part to tell you what we did. But we had to continue to get legal assistance for 900 people that were coming in on a regular basis.
Right.
Lakeshore Legal Aid came, and they were on computer with us at first. It was very difficult for them to see all of the people that came, and they were trying to do like a little intake process at the time to see if they could even represent them going forward. I think that is a better process that they've got now, where they're really not representing, they're coming in and giving advisory information, which has made the world of difference for us. It moves quicker. We don't have to worry about it if they're actually being represented, and they can talk to the client later if in fact they choose to represent the client, and then they can file an appearance. That wasn't the case at first. So we were spending a lot of docket time with trying to put people in breakout rooms to talk to legal aid and to try to see, where's the process gonna go from here? When the administrative orders required us to do a pretrial, lawyers were like not happy. That was something we had never had to do. When you came to the first appearance, your case got adjudicated or not. And if it was set for trial, it was set for trial. It was something firm. That was the end of us touching it unless it was set for trial. Either you're going to enter a consent judgment or you're going to have a default judgment. That was it. The pretrial really created challenges for us. Because we had so many cases, we didn't have a lot of Zoom docket time.
Right.
And I will tell you what we did later, as I said,
Okay.
before we went on Zoom, that we thought was fairly innovative. But we couldn't fit these cases in every 15 minutes. It was literally impossible. And every 15 minutes, we were setting literally 10 cases or more. And it was just impossible to handle that kind of a docket and then give the people the attention that they needed. We kind of stayed those first cases and told the people about the process and hoped that they applied. That's all we knew. And we knew that the funding for that ran out, I think, sort of like December of last year, but it wasn't very efficient the way it was done. And we weren't able to easily keep track of what was going on with that first set of eviction diversion cases. When we came up on this new SIRA matters, it was a little more structured.
Right.
But we still had problems because we had no idea what was going on with the SIRA applications. People were filing them, we thought, but we didn't know. Many of the landlords' attorneys were saying they weren't getting any information about the applications from Community Housing Network. So here we are on a first or even second pretrial, and we just found ourselves in some kind of adjournment nightmare where we were just constantly adjourning because we didn't have any information. We took some action, and I'll talk about that later, to try to fix that situation, but we kept finding ourselves not getting the information that we needed to understand where the case was going.
In a timely fashion, right? So
Very timely. And then when we did find out that there was money to be paid, we didn't know when it was coming. We had no idea. and then we would adjourn and the money still wasn't there. So landlords were kind of getting, they were happy that they were going to get something, but they were also like ready to throw in the towel and just put in a judgment, which the order precluded us from doing, but it's sad, that if these things didn't happen, the most recent order says within the 30 days, if you don't have an answer about funding, within 45 days, if you don't have the check, then, we could move the case on. Quite feasibly, that wasn't workable. Everybody wanted the money. They just wanted to know what was going to happen and when. And we ended up in this court using our authority on the court was to just adjourn anyway, which is what we've been doing until we got an answer. So logistically, those were a lot of the challenges that we had. We had Zoom challenges. Everybody knows the Zoom challenges. I don't even think I need to talk about.
Not at all, right?
Zoom. That's a whole nother conversation, but we did have challenges with all of that.
Thank you, Judge Johnson.
So that's my nutshell of some of the problems that I had.
All right, thank you so much. Let's go to Judge Noel, who's on with us as well. Let's hear what your court had challenges with as well. Oh, you're still on mute. Let me see.
There
we
Now,
go.
Okay. I agree with everything Judge Johnson said. The initial problem, and it's not an uncommon problem for the district court judges, is that we basically had no guidance as to how to proceed. And that was followed with an abundance of guidance, some conflicting as to how to proceed. But initially, and I think each judge, when I do new judges school for the MJI, I say, you're developing really your own common law here because there's very little guidance beyond the statute itself. And I was having to ask myself the question, if there is no moratorium on evictions, what am I going to do about this? Because in the spring of 2020, the last thing we wanted to be doing was evicting people. But then the guidance came along as the courts were closing down and everything ground to a halt. And then it was sort of a matter of waiting to see when we were going to be able to address these issues, because as Judge Johnson indicated, we had cases in progress. We had cases that needed to be opened by our staff, and we had landlords that were very concerned on behalf of their clients. I met with the landlords in our area on a couple of occasions just to keep them up to date on what was happening, what would need to be happening, and trying to develop a level of trust. Eventually, the eviction diversion program came about, and that was certainly helpful to us. And I agree with Judge Johnson that the SARA program is an improvement on the eviction diversion, because the first thing we had to do with eviction diversion is convince the landlords that they should take 10% cut on what they're owed. Just from the volume of it, of all of the cases, we wouldn't have been able to do what we did without the assistance of legal aid. So we had a legal aid attorney available. We set up our docket so that our docket in our 58th court, which is in Holland, Hudsonville, and Grand Haven, so the legal aid attorney would be available to at least advise people how to make the application. And it's gone very smoothly since then. It's the two things that had to be balanced were the need to make sure that the tenants and the landlord were completely aware of what options were available to them, but you wanted to do it on an expedited basis. And the insertion of a pretrial conference into the process, as Judge Johnson mentioned, was actually, I saw that as an impediment, because then you're asking people to come back for a second time for a pretrial. So we just handled it. We called the initial appearance a pretrial and gave the people their advice and made sure they understood how they could make that application under the EDP program. If the application had already been made, we'd adjourn the case without a date, keep it off the docket. If they hadn't made an application yet, then we keep the case on the docket to make sure that they're going to do that. The logistics were daunting, but once we got used to it, and once the participants in the system trusted the system and trusted what we were doing, it's gone very smoothly since then. But it was a lot of anxiety at the time. The technologies were not good, but they were the best we had. And it's probably the smoothest part of my operation now, but it's just something entirely different from what a judge is used to. A judge is used to presiding over an adversarial contest. And now we're acting as a social relief agency. But I think we're doing a pretty darn good job of it, because a lot of people are getting what they need to stay in their homes. And that's the ultimate goal, is keeping a roof over everyone's head.
Exactly. Thank you, Judge Noel. Let's hear from our legal aid partners now. Shannon, would you like to start us out, and then Emily?
Sure. I think at legal aid, we face some of the same problems that the court did as far as just the volume of cases. I'm not going to say at legal services we're not used to having a high volume of landlord tenant cases. I think that's one of our highest areas all the time, but just the enormous volume that this brought on and that the courts were seeing. We were lucky in that we had EDP's eviction diversion program set up in some of our counties. So we had a model that we like to use, that we could talk to the courts in our jurisdictions about setting it up that way. And, just having that model that we were used to. So that was helpful. I think another one of the challenges was, we were seeing all of these non-payment cases, and yet there were still filings for termination of tenancies. And so our office struggled with how to staff both. How can we take on the termination of tenancy cases while still maintaining our presence at the EDPs for the non-payment cases? We had a difficult time finding attorneys to hire to increase our capacity to handle these cases. And I think, to be honest, we're still struggling a little with that same issue. So I'll pass it to Emily to talk more about kind of the challenges legal aid has.
Thank you.
Thank you. So I agree with Shannon that we've always had a lot of landlord tenant cases. I think the difference that we saw in our service area was we cover 45 district courts. And so we had to spread our staff out to accommodate all of those courts. And so it was challenging getting the staff on board to do that, training the staff about the constantly changing, administrative orders and each court's different preferences. And, I think we all, as legal aid attorneys, we were all so excited about this money. And we finally had rental assistance to provide to people. And so we all went into it with an eagerness that we will probably never find in ourselves ever again. But we were just so happy to have this money and this option for our clients finally. And I think what we underestimated was the infrastructure in place. We had to form, we had relationships with some courts and some agencies, but not on the level required to make this eviction diversion and SARA program successful. We really needed to have contact people at each of those agencies. We need to have regular check-in meetings. We just needed to be able to pick up the phone and call a judge and say, Judge Johnson, or Judge Johnson needed to be able to call me and say, Emily, where's Lakeshore? There's a client here, and you're supposed to be here. Somebody is supposed to be here. And so it was like that, working out those kinks at the beginning to kind of get that process. And don't think Judge Johnson did not call me personally multiple times.
I know she did. She called me too.
But we really needed to have that. And we, again, we had relationships in place, but just the level of that infrastructure that we really needed to grow. And it was time consuming. And then, our attorneys were kind of using a right to counsel model in most of the courts. And because we wanted to, right? We wanted to be able to help everybody and represent everybody and show up and make sure they got through the process. And then I think now, as time has gone on and we've gotten to the point where we have that infrastructure in place, we kind of know, okay, this is the type of case that you have. You really just need to work with your housing agency to get that SARA funding. Or, we've screened your case and there are really some triable issues here that we need to move forward on representing you. So, just working out that process and that infrastructure with the high volume of cases going on, I think was the challenge. And I think just that, like, the exhaustion that we all faced at the end, with that, it was December 30th and we were all up at midnight trying to get the last money in the last applications process to help as many people as possible. So, it was a really like fast-paced situation there for a little while. So that was, I think, what I'll say was our biggest challenge.
Great. So I think you really kind of characterized and captured, all, the breadth of challenges and the scramble and the innovation that it took. So we'll delve into a little bit more of that. I want to do a quick poll right now, if we could, just to kind of gauge how many of our SARA and agency participants out there have had previous experience working with the court. Can you put up that poll now, please? I don't know if Allison is with us. All right. Is it coming? There we go. So how have you engaged with your court and legal aid partners? And we'll say right now, during this SARA era. Email only, participate in meetings. Are you attending virtual court hearings? Are you sharing the SARA status for court dockets? Or is there something else that you're doing as well? So please, you have a single choice here. So your best answer, and go ahead and have make your selection, and we'll show the results in just a second. Can we pull up the results? Allison, do we have? I'm not seeing on my end. I don't know if there's. All right. Oh, it's on an error code. All right, why don't we just go ahead then? I'm going to end it. I don't think it registered. So my apologies for that. We'll see if we can figure that out. All right, let's go to the next slide then and talk about some of the innovations and best practices that all the pivots and changes that we all encountered. So Judge Noel, would you like to start us off here?
Sure. I'm just kind of unmuted. And it was true, we were, a lot of times we were making things up on the fly as to how we were going to do that. But some of the things that we figured out early is we had to take advantage of limited resources of legal aid. So I consolidated the 2 docket landlord-tenant docket into 1 docket that I presided over. So we didn't have to have a legal aid attorney bouncing between 2 separate courtrooms here in Holland, and then accommodated our dates for having those for dates that legal aid was available. And when people came to court or appeared remotely, and it really didn't matter as far as the tenants were concerned, I didn't see any appreciable difference between their level of understanding or the ability of legal aid or the HARA to respond to them. But we wanted to make sure that they were fully aware of all of the options and rights. Now, if I had taken the time to recite what SCAO has asked me to recite with each person coming into court, we wouldn't have had time to do that. So, my record probably doesn't look very good on a lot of cases. I had to be sure in my own mind and my conscience that when the people were leaving the courtroom, they understood exactly what was going on, what their options were. We had some difficulty because my court has an overlapping geographical boundary involving both Ottawa and Allegan County, and both with the Sarah Park EDP, the HAR has strictly observed the county boundary. So we're actually dealing with two separate agencies that are accepting applications from the county. We had to make sure that the applications were going to the right agency because we had many instances where they were not. So in terms of innovations, we made sure that we knew the tenant knew by the time they left the courtroom what they could apply for, how to apply for it, where to apply for it. And then we've been able to just sort of let the process go along and work itself out. Yeah, we still have the termination cases, but we've moved that to a separate docket, and termination cases get done as quickly as we can do them, but we're certainly prioritizing the non-payment cases, unless the termination is based on police activity or dangerous conditions or something like that. That still gets high priority, but we've tried to concentrate our non-payment of rent cases in one court, one legal aid attorney, and we've been blessed by two separate attorneys who have just done a great job of making those explanations to the tenants that I was supposed to, but really didn't have the time to do. So anytime I was quizzing a tenant about their understanding, they were always able to tell me that they understood exactly what was up, what they had to do, what they had to submit, and how to go from there.
Thank you, Judge Noel. Judge Johnston, would you like to talk about some of the innovations in your 46th District Court?
Sure. When we first started with the regular EDP, as I said earlier, we had so many cases that we were used to having these huge, landlord-tenant calls, and SCAO had specifically said, well, you can't have that, you can't have everybody in the building, and they wanted us to go to Zoom. And we really didn't know how we were gonna make that happen. So the first thing that we did that was kind of innovative is, well, since we couldn't have the people in the building, we took the people to the outside of the building. So we have a courtyard between in our complex between like the court and the city offices and the police department. So we were able to set up shop out there and hold some of these first hearings outside, at least while the weather was warm in the summer of 2020. And so that enabled us to at least have the first hearing, enter a default if the people didn't come, because otherwise you would have to adjourn if it was a Zoom hearing, adjourn it and give them an opportunity to appear. So that's what we said. Well, we'll just make the first hearing an in-person hearing, and we'll do it outside, and we were socially distant. And we had a table set up with our civil division head who gave them all the information that they would have needed about any eviction diversion program that was out there at the time, any information about any CDC information that was out there for the declaration at the time. And then we had another table for the landlords, lawyers to meet with the tenant, and we put a divider up there so they could talk and not have to be, directly face to face. Then we had another table of different computers. We took all of our laptop computers and put them out there because we had to deal with the fact that Lakeshore Legal Aid, which is, who services us through Emily's organization, we had to deal with the fact that they didn't have any manpower. And so we have these in-person hearings and they said, we just can't come. So what we said, well, okay, if that's what you guys can do is do Zoom, well, we're gonna set you up with some computers so that they could have a little private area to talk to the tenant on computer as we sat outside. So that kind of worked fairly well. And we noted that not as many people were coming to those hearings as we thought, because I don't think they knew about any eviction diversion program. They really didn't know about help, and they just weren't coming in the droves that they used to come. So we decided that we would try to then implement the docket on Zoom. There are 3 judges here, so not one could take the whole docket, because the way we're set up, we all alternate different days with different kinds of hearings. So it might be a civil day, it might be a state docket day with a state prosecutor. And since we have 5 other subdivisions, at least 4, which we call Lathrop Village is a city, they have a separate docket. Southfield has a separate docket. Bingham, Pines, Franklin, Beverly Hills has a separate docket, and all those lawyers for the criminal cases appear different days. Landlord-tenant is usually fit somewhere in the middle of, in between that on all of our dockets. So it was very hard to change that, to have one person try to do all of the landlord-tenant. So we kept it that way, and we went to Zoom. And so we went to the 15-minute intervals, and they would 15 to 30 minutes, and they would schedule a certain amount of cases there within that time frame. So what we decided to do was, I wait for my 8:30 to my 9 o'clock cases pop in. I give them all the speech. Judge Noel is right. It's impossible to give that speech the way you should to everybody. So we would just wait till we would have a whole waiting room full of people. I give the speech once. What I found that really helped with the speech was, I have visual aids and I share my screen. So I have the Sierra flyer front and back. And some of my Lakeshore lawyers say, boy, you do the best job of anybody that we have seen with explaining this and giving the resources, and I do it really quickly. So I show the front and the back of their flyer from Community Housing Network, who is our HARA, and what they need, and I show it there. And I found that this helps, because if you just kind of tell them to apply, they don't know what they need. So I just kind of go over that. And I've seen people actually apply, and we're not adjourning because they didn't know where to go and they didn't get all the information. So I would share that. I had found some additional resources myself, including the Oakland County program. So I put those resources together on a separate sheet that I would also tell them to screenshot. I told people, screenshot this, and if you can't, call my assistant and she will email it to you. All of those documents. So that really helped people to understand what they needed to do. And I don't know if anybody else was doing it to that extent, but I really found it stopped me having to adjourn because so-and-so didn't apply. Another thing we did was, instead of just giving the 30 days, we just went to 45 days, because we were finding it was 30 days, we were coming back and adjourning it anyway, because application wasn't processed by CHN, Community Housing Network, that quickly. So by giving a longer, the furthest length of time you could, seemingly helped us get some answers. The problem of not knowing the status of the application, well, I called Lisa Chapman here when she was at Community Housing Network, and we got all of our folks on the phone, and we decided that we could get an update because I wanted to get on the actual online, but I couldn't get into their portal. Well, we're not, the courts aren't allowed to get into the portal to see what's going on. So short of that, I said, I need something. My judges don't know. The lawyers are saying they don't know. They're not getting information. So now what we do now is, someone from CHN, every docket, we send them a copy of our full docket. They send us a spreadsheet back with all of their names. Have they applied? If so, here's their serial number. Here's the specific status of where they are. We're waiting on this, or we're not waiting on that, or they've been approved. And if they've been approved, it tells us how much money that the landlord can count on possibly receiving through this process. And it also tells us who the case manager is. Because sometimes no one knew. And so they didn't know who to contact and what the problem was with the application. So if I don't know if they're doing that with every court now, but I think I started that, and it has just worked out beautifully. We don't really have any holdups now. Everybody is informed, and we do really want to thank Caitlin Sanders over there at Community Housing Network. She's the person that generally goes through that whole list of documents. We got a lot of people, and tells us what we need. So I thought that was very innovative. So if you don't have a direct connection with your HARA, you need to do that to get that information. I think I went through the fact that we do try to give the advice and rights in a huge group setting, which really does help us move those cases along. And then what I do is I talk to each case after that, just to make sure that they're gonna apply, did they apply, and we keep notes on it. We ask the landlord for how much rent it is, and if they haven't applied or if they are going to apply, then we adjourn it those 45 days. So those are pretty much the most innovative things that I can think of that we've tried to do to keep our dockets moving on. And so guess what? Today, we started back in person just to see if we could move cases any quicker with an in-person docket. And believe it or not, we did get several notes from people who say, oh, I got COVID, so I can't come in. But other than that, it seemingly moved okay this morning. And I was able to do the same thing with everybody in the courtroom that I would have done on Zoom. We're not wedded to that yet. We might go back to Zoom, but we're just trying to see if we can get back to some kind of normalcy here. We didn't have any attorneys here for the first hearings because Lakeshore only comes on certain days. But what I do is I give the Lakeshore number and tell them they're not your lawyer, but they can answer any procedural or informational questions in an advisory nature, which is what they do when they come. So I'm hoping that filled the gap of not having a lawyer here.
Great, wonderful, Judge Johnson. I know there's lots of innovations going on. I see people in chat, a lot of collaboration and still attending the pre-trial Zooms. Some people showing up in person and doing a lot of, conferencing together and meeting with their court and legal aid partners. So let me go to Emily and then Shannon and hear what you have to say about the innovations that you employed.
Thank you. So we, I think Judge Johnson really highlighted some of the innovations that we needed to have with the court. And so that is, I agree with all of those things, kind of spreading the net over who has access to the information, who can provide it, because before we were acting as that liaison between the courts and the HARAs, and it was just very time consuming. And so doing that certainly helps. The automatic meetings built in, like the check-in meetings, so that if there is a process issue, we already have a check-in meeting set so that we can talk about a specific case or a specific process that needs to be tweaked. Having like an emergency process, like there's a writ issued, how do I get this? How do I get the HARA to process a check today? And which I am happy to say we at all of our HARAs that we work with have that process, and we have gotten checks in less than 6 hours cut for people who have a writ issued. So which is just amazing. And I know takes a lot of work on the HARAs, and so like that is just huge. Internally at Legal Aid, we had our typical attorneys, like our normal litigation staff attorneys, staffing all these dockets. Once we kind of had that reprieve between EDP and Sarah, we took a step back and looked at our structure. And we actually hired a director of eviction prevention with supervisors, with teams, so that we had dedicated people to different courts. And that was their sole function, was to really screen the cases and make sure that we're handling cases that are a simple Sarah case that just needs to get to the HARA and get followed through the process, versus those cases that require a trial and some discovery. And so the litigation attorneys are still handling that type of case. So we kind of bifurcated our internal structure to allow people to really focus on that effort, which has been I think, good mental health relief for a lot of our staff. Unfortunately, we could probably hire 8 more attorneys tomorrow and still not have enough attorneys, because there just aren't enough attorneys applying. And so, we're still looking for people to come work on those teams and staff those court dockets. So, but the innovation is there. The restructuring was done. And so So I think that was really what we found to be the best practice.
Thank you, Emily. Shannon.
Yeah, and I'll start by just stressing the ability to communicate with the courts and the court staff was our best innovation. Like we can literally, call almost any district court in our service area in our 13 counties and get information that we need to get that, we just didn't have those connections in the past. And we too still have, I would say twice a month meetings in most of our counties, sometimes once a month, depending on the size of the county. Our program's a little different than Emily's in that we have some very rural, small counties, and then some, larger counties like Washtenaw County and Lansing and Ingham County. So our overall program looks different in each county that we have. We did also kind of have to step back and say, our attorneys can't keep doing this, that we can't keep having attorneys in court every day. They have to have time to kind of track their cases and put in their case notes and do their time and draft different, things. So we actually went a different route. We didn't hire supervisors or a director. We decided to invest some of the money that we received in hiring some support staff in our offices. Our offices had really moved away from hiring support staff and used in the past had really focused on hiring attorneys to represent people. But this allowed us to have some money to have those people who could answer the phone, answer questions, connect people to our housing resource centers, and do kind of the non-attorney things for our clients, and then allow our attorneys to really focus on representing people in court. And so we went a different direction, probably has a lot to do with the size of some of our counties as opposed to where Lakeshore lives. So, and I just want to throw out some support for Zoom hearings. I don't think that we can continue to do and represent the people that we're representing without having some access to Zoom hearings, at least for pretrials. Doing a trial over Zoom, I've done them. It's very difficult. It's very clumsy. It's, I think probably for judges, it's hard to judge credibility that way and a lot of different things. But for pretrials, it enables us to be in a county that it might take us 3 hours to drive to for a 15-minute hearing. We also recently did a client needs assessment where we sent out almost 4,000 surveys and got feedback on the way we're providing services. And even our clients said having a Zoom hearing, especially for pretrials, allowed them to appear. We had one client that wrote back and said, I just started a job. I had a landlord-tenant case, and I wouldn't have been able to attend without the ability to just take my 15-minute break, handle my business, and then come back. Where that client would have spent probably 3 hours in court waiting for their case to be heard. And so while I understand the difficulties of Zoom and maybe the technology challenges, it really is a godsend for some of our clients and for some of our attorneys' ability to be in court, as opposed to just like having to pick their employment over that court hearing or not having childcare over that court hearing. So I'm going to throw out a little plug for continuing to have some hearings over Zoom.
Thank you, Shannon. Judge Johnson or Judge Noel, would you like to, any further thoughts, or should we move ahead and talk about lessons learned?
Well, I'll definitely say that there's a positive reason to have some of these hearings on Zoom. The not so positive, you already know, is people take too much advantage of the ability to do Zoom because they're naked, they're not dressed. Other people are running around behind them. They're in work, so heavy equipment sounds are going on. Babies are crying. It makes it very difficult for me because I can't hear. So I spend a lot of extra time, people falling off and coming back on. I spend way more time doing that than I would at a hearing. So on some of these, I make them have to come in anyway because I can't get done what I need to do, even on a pretrial, because of all the other distractions that they have going on. But I do agree with Shannon. Overall, it does enable a lot more people, because I've seen more people appear now than I did before in the summer when it was a serious pandemic last year, because they do have the ability to appear over Zoom. So I think we're going to have to find a happy medium and just pick and choose how we do this and put some people over to in person if need be. So I think the in-person hearing is definitely hasn't left, even for a pre-trial. And I do agree, I can't do a trial that way. It's almost impossible.
It's-
Even nobody can even see the documents easily, especially with the underrepresented population. They don't have access to the technology they need to get the documents to see it. So it takes too much more time. So those will always, I think, remain in person. But even some of the pre-trials have to be put over. So I would agree on that as well.
I am hopeful as we continue to use Zoom that Zoom etiquette improves. I think people learn, it's been a huge learning curve, and I've seen it in like trainings that we at Legal Aid have put on for people. Like we've gotten a lot better at, remembering your camera's on, remembering to unmute, making sure, which my dog will probably, but my dog isn't barking in the background or whatever. But I'm really hopeful that as this continues, that people will definitely improve on and learn about Zoom. And at Legal Services, we do provide, our clients with, hey, this is a Zoom hearing, but it's still court, and these are the rules. And so hopefully, as that spreads, some of those issues will go away. We're always going to struggle with some technology issues, I'm sure. Some of our clients just don't have access to adequate internet. We did put Wi-Fi in all of our parking lots so people could come and use the Wi-Fi at our buildings. We had hearing rooms set up for clients to come in if they needed to use a computer. And we worked with partners to do that as well. So we're all still learning.
Yeah, I agree with that. And one thing I will say in addition, let me make my last comment on this, is that, there are some legitimate reasons why people should get an adjournment. And I found that they're trying to get on Zoom from a hospital bed, that the nurses are trying to help them, get on, and they can't talk. And I'm thinking, this man looks like he's in critical, condition. We would have just adjourned the case. There are some reasons not to have to try to come on Zoom. And then, of course, other people, I had a lady that was arrested in a car that got stopped. And I hear the police saying, "Step out of the car, ma'am." And I thought, this can't be happening. So I don't know where the happy medium is, but, people need to understand that they need to at least be seated somewhere in a location, in a house, not driving, because too many people drive and you can't hold court when they're driving. So maybe this etiquette gets passed along. You try to tell it. Some people put it in their waiting rooms that you can't do this and that, and it goes on deaf ears. So, but I think that the Supreme Court is going to have us using Zoom regardless in some capacity. We're just waiting to see what that direction is going to be.
Right. Thank you. Judge Noel, did you want to make some comments?
When I start talking about Zoom, I tend to go 20 or 30 minutes, but no, I think that judges should always accommodate requests to do things by Zoom, but I think it's also important to understand that particularly district court level, all district courts are local, that for many people, not just us baby boomers, but for many people that appearing in court is just as convenient as appearing via Zoom, and that the person may feel more comfortable in a face-to-face situation with a judge than doing it remotely. I know I'm more comfortable dealing with people face-to-face, but Zoom's not going to go away. It was a godsend during the worst parts of the pandemic, at least what we thought were the worst parts of the pandemic. And I'll always accommodate a request for Zoom for a summary proceeding activity. The lawyers take advantage of it, certainly. All of the outstate lawyers take care of that. And one of the problems with Zoom is that your phone will go off when you don't realize it. And that can be a problem. But I'm not a huge fan of Zoom. I prefer the in-court proceeding, but I certainly understand the need to convenience people.
Sure, point well taken. Thank you. Let's go to our next slide then. And as we're close to the top of the hour, so if people can roll over and stay with us, if our panelists can, we can hang over a little bit and just talk about some lessons learned. So having the, ability to look back and think back and, what we know now what would you have done differently? What changes maybe were the most effective that you implemented? And just thinking about the future of eviction diversion programs. We're in talks at the state level about continuing this effort after the SARA funding goes away, looking for other pots. So what would you think about recommendations for that? So let's start with Judge Johnson.
Well, you know, I really don't know what I would have done any differently based upon what I know now, because I think we did the best we could when all this started. But what I can say is recommendations for the future. Now, we had started at one point asking the landlord's attorneys to serve information with their summons and complaint about the original eviction diversion program, thinking that we could jumpstart the process in some way. So what I would like to see, if this is going to be something permanent, I'd like to see a way that maybe that would be a requirement that, and see, you can serve it, but you can't make the people make the phone call to follow up and make the application. But I'd like to see that as a requirement. And so therefore, and if there's some way that the list of information of who filed could be given to the agencies could try to reach out to those persons that haven't filed or who could file and see what they're doing. And I don't know, that's a lot of work I know on an agency, but at least by the time they came to court, something would have been in place. That I think needs to happen. If there can be a format where the lawyers agree to serve and give the information and it's expressed. And I saw a lot of landlord managed property managers saying we were calling tenants and giving them information. So if that process could become a part of the system where they're encouraging this application process and the landlords are all know that there's a permanent eviction diversion program going on with money, then by the time we get to the pre-trial, you know, a community housing network or any other HARA, if they're still around at that point, already has what they need. They've already started the application. It would shorten the length of adjournments and necessary problems that we have with all of that, because we've already started it before it even got to the pre-trial stage. So that would be my recommendation for the future of eviction diversion program, is to have everybody kind of working together, understanding this is going to be your role in it. You're going to serve the information. Your property manager has something to gain. He or she is going to make some calls to those tenants ahead of time, telling them even before you file, this is what you need to do, so that if you do file, they've already got to jump on it. And then having the agency, if they have the resources, and I know they don't always, to be able to reach out and even getting that list over to legal aid, so that legal aid knows, well, these are the people that, you know, could have applied or did apply. And so they know what to do if they need to reach out to those people or not. So I think if we could get ahead of this, especially for courts that have large dockets, that this would really help us in finding the time to, because we have to, every time we have to find, we have certain days that we've been putting all of these adjournments over. It's just like never ending. We have to find a whole day or two or three with nothing but these return LTs. And if some of them didn't get dismissed, and I'll tell you, a lot of landlords are not doing conditional dismissals over here. They're just asking to be adjourned until they get the money or until they find the status. They're not doing. I have one that just started doing conditional dismissal. So we don't have the space for this. So it would really help if they could do something that it really creates a little bit of a room in our dockets, that so that most people already have something going and we don't have to adjourn as much.
Thank you. Judge Noel?
Well, I'm thinking, and we spent some time talking about the relative convenience or inconvenience of in-person appearance or Zoom appearance. The lesson learned and probably the most effective implementation of change that we have done is to attempt to resolve the matter with one and only one court appearance. And we can do that. Number one, the landlords love Sarah. And when a person is falling behind in their rent, it's often the office staff at the apartment complex that are telling the tenants about their ability to apply for assistance through the Sarah funding program. So many people who are coming to court now have already started the application process. And in that situation where, number one, they're familiar with the process, they've started it, they're waiting for a determination or maybe some more paperwork from the HARA. I take it off the court's docket. I say we're adjourning this without date. If there's problems, landlord, give us a call, we'll put it back on the docket. But that way we've been able to save a lot of docket room for cases that the vast majority of which are going to be resolved through a conditional dismissal order. And it just makes it easier for the court staff, for the landlord, the tenant, for the legal aid attorney. We wouldn't be able to do that way without the legal aid attorney being able to answer questions for tenants that may pop up, but it's worked fairly well for us. I'm hoping that there'll be a continuation of eviction diversion programs in the future. When I reported to our county's housing commission on the results of the eviction diversion program, I recommended to the county that we consider our own local eviction diversion program, because even after the pandemic ends, there's still going to be situations beyond the control of tenants that cause them to fall behind in their rent, and that local option should be available to us. I know it's in place in other similarly sized communities in the state. So surprisingly, the county was received it very favorably. So we're in the preliminary stages of determining what that local eviction diversion initiative is going to look like.
Let me
Go ahead.
speak to that too, because there was a point when Scale was having seminars on eviction diversion programs, and they had presentations, and I was there. And this was several years ago before CIRA. And I tried to get on that bandwagon. And it really, if I remember this, Brad, it took the way it was set up is that you would have all your major filing landlords would be on board to go through the diversion process. You would meet with a representative of like the DHS. And so that you would get the names of those tenants that were going to be evicted. They would go through some kind of pre-process and screening program so that they would know if they would have been eligible for whatever the funding would have been. And I don't know what the criteria was back then. And then by the time they came to court, you would kind of, quote, divert them out of the system, dismiss the case with the understanding, similar to what we're doing now, that the rent was going to be paid. And I tried to set something like that up, but it required us to have a lawyer, obviously, for the tenants to be on board as well. And before Lakeshore, I can't remember who our legal aid was, and something happened. We talked to them, and then I think they just kind of stopped, went out of business. And so then it was Lakeshore. And then with Lakeshore, you know, they really didn't have the manpower. And so we just didn't pursue it. And then COVID came. But it's been, we've tried making numerous phone calls to get it going years ago. So I agree with Brad, Judge Noel, that we do need this. It was a problem before COVID. COVID just exacerbated the problem, but we got lots of people that have lost jobs and needed money, even just to tide them over for an interval. So I think this is definitely a good thing to do. And if they don't do anything on this larger level statewide, then I certainly intend to pursue it again on the local level, pursuant to the way that they told us we could try it before.
Sure, wonderful.
It's Lakeshore, so I'm putting you on notice, Emily.
Get busy, Emily. Now we're trying on the state level to, you know, forecast after whenever it is that Sarah funding runs out to get some funding to continue. And I know some communities had done this pre-COVID, so we can, you know, learn from there how it was structured on a local level. So Shannon and Emily, any lessons learned as we're winding down here?
I'll jump in real quick. I would say for us, you know, the restructuring of our offices to allow for some support staff is really, I'm hoping that we'll be able to continue to that. I think for us, you know, the option of having that first pre-trial and meeting with clients and providing that information and getting some time for them to apply for rental assistance has been really helpful. And I know it's time consuming for the courts, but it allows us and the tenants to come into a place and get some information and start to problem solve before that second pretrial. I think the other thing I would love to see continue is the ability to apply for rental assistance before you get served with a summons. I think it's more difficult to settle a case after a landlord has gone as far as to file a case. And so if we can continue to refer people to our local housing agencies before a summons is actually filed, I think that's been a tool that we've used, especially in Washtenaw County, and it's been very helpful. And then I have, the use of conditional dismissals for clients to, even when they're not going to be able to maintain their current housing, having those conditional dismissals can help in the next place. And I know there's some states that even have sealing of eviction records. And I would love to see that come to Michigan as well. And I guess I'll leave it at that. I know we're running out of time.
It's something on my bucket list too. So
Yeah.
let's talk about that. Not here, but another day.
Yes.
Hey,
I would love to talk about that.
perfect.
Yeah, and I will refrain from making any comments about funding because of restrictions on my funding. But I can tell you what I witnessed before the pandemic. And if anybody here has been in one of these presentations with me, you've probably heard me say, we had a housing crisis before the pandemic. And before the pandemic, requiring people to have judgments to get rental assistance is, getting those conditional dismissals. It's been huge to preserve people's right to housing in the future. Just like Shannon said, all of those things like that the system was doing the things that we thought was good, but really on the flip side of it, it was really just preventing people from being able to get housing in the future and get that rental assistance, requiring somebody to come up with $1,000 in 10 days. In those 10 days, they're trying to contact all the agencies they can and also choose which toys they're packing in their trunk, for their kids. And so that having to make that decision, do I try to spend these next 10 days tracking $1,000 down, or do I just pack up my things and go get my kids enrolled into a new school, move in with my mom, find a different job that I can't walk to anymore. So it's really that understanding of what people are going through in that housing crisis and really being able to address those. And I think our the guidelines from Sarah have been amazing to address those things. And so I think those have been the most effective changes. So that's all.
Thank you. Thank you, Emily, for reminding us. I mean, at the heart of this, there has been and will continue to be a housing crisis. So we all need to commit to working on that other end too, because landlords are a key part of it. We can't, develop and build our way out of it. It has to be partnerships with landlords as well. And so they're a critical component. But I did also want to mention, and you can skip the next slide, Eleanor, and just go to the last one. But, the court administrators and personnel and all the legal aid attorneys and the Sarah staff that have been working so hard to get this money out the door and adapting and, pivoting on a daily basis. Your efforts are just so important, and we really appreciate that. So I just want to see if anyone has any final parting thoughts or comments or something that you didn't get to mention that you want to do so here.
Thank you for having me, and everybody keep up the good work.
Yes, thank you.
Thank you to our panelists. I really appreciate you. Judge Noel, Judge Johnson, Shannon Lucas, Emily Calabrese. We're hoping to continue the conversation and provide information that's helpful and have more robust and productive conversations going forward. So feel free to contact me if you have any thoughts or suggestions afterwards. And I just want to say we're so grateful to all of you for your hard work to keep our fellow Michiganders in their housing. And I just want to wish you all a happy and healthy holiday season. So thanks so much, everyone. Thanks for being with us today.
Thank you, Lisa.
Thank
Thank you.
Bye now.